CR1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case number CICV220402. Good morning, counsel. Each side is allocated 20 minutes for oral argument. Appellant, if you wish to reserve a portion of that time for rebuttal, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask everyone in the courtroom to make sure your phones are off so we can avoid interruptions and embarrassment. We've read the briefs, we've conferenced the case. We'd encourage you to keep that in mind as you present argument today. Our proceedings are being recorded and will be posted eventually to YouTube, so please, as you begin your presentation, tell us your name and the party that you represent. With that, Mr. Phelan, you may proceed.
Thank you, Your Honor. Good morning, members of the panel. I would like to reserve 3 minutes of time for rebuttal. May it please the court, Grant Phelan on behalf of Fitness International, LLC. Before the panel today are my client's appeal of an order that was entered granting summary judgment to the appellee and against my client, a tenant on 3 distinct and separate leases for fitness spaces here in the greater Phoenix area. Now, this lease or these leases concern events that occurred following COVID and COVID's sort of overtaking the Arizona economy. These appeals, and in turn the underlying cases, are different from virtually every other case that will come before you concerning COVID rent, and any case you may have read, for 2 distinct reasons. The first is that this concerned a fitness center which was required to close and close completely. This was not a situation we're dealing with a pizza place where they could do some takeout. This wasn't a situation with a food or a clothing store where they could do online fulfillment or delivery at the curbside. This wasn't even a grocery store or a convenience store that actually probably did better as a result of COVID. These were orders that were entered by the governor that said, go home, lock the doors, and don't come back until I tell you. Over our protestation, and there was nothing we could do about it.
But they also closed other service stores, organizations. Hair salons were closed.
Sure.
Nail salons. So this isn't all that unique.
Well, it is in this category of space. The other reason it's different, Judge, is because my client actually negotiated for and embedded agreements between the parties where there were express representations, warranties, and covenants that would essentially guarantee that my client would have the right not only to possess the property, because after all, when you're looking at the totality or that bundle of sticks that we all learned about during first-year property in law school, but rather the ability to use the property, which is essentially what a lease is. It is a transfer of both possession and the ability to use.
And isn't that standard in most commercial leases?
Well,
and I don't know that I've seen a commercial lease that doesn't say why you're leasing it and what you're going to do with it and allocate that.
So, Your Honor, and I appreciate your skepticism, but I'll direct your attention to the actual language of the lease because I think it's, again, important, right? This wasn't simply a representation that we made that we would say we're going to use it for a fitness center, right? Because, after all, that was understood by both parties, right? It's no secret here that the parties are actually subject to multiple lawsuits in multiple states. We won in Texas, we won in Florida, they won here, right? There's been plenty of submissions of other opinions, of other laws, other states to this court. What we're here to talk about are these three leases. These three leases, which begin in section 1.9, and the language that the parties use, and this is important because what we're talking about here is language, right? Language that is supposed to be reviewed by the court to determine the intent of the parties. So what the parties said was, tenant, my client, or its successor or assigns, shall, not may, not could, not should, but shall have the right throughout the term, not for a brief shining moment, not for a window, but throughout the term and all option terms to operate for uses permitted under this lease.
And that's a paraphrase of language that I'm absolutely reading. But does that, didn't your client, wasn't your client under the lease? And again, we're talking about, what, 15-year long-term commercial leases?
15-year long-term lease with options.
45, 50-page long documents, comprehensive, integrated provisions, right? That differ in at least one material respect in the force majeure provision. But didn't it require your client to do things like get permitting?
So it did require it.
And what if your client wasn't able to get permitting? Would you then sue the landlord?
No, but then again, Your Honor, remember when you look to a frustration of purpose argument, right? You don't ascribe fault under frustration of purpose.
And I'm really looking at your argument under 1.9. 1.9 doesn't say that you can use this property for a fitness center.
No, it says for uses permitted under this lease.
If you're able to comply with other things like permitting.
Which we got.
Right, but it's not a warranty by the landlord that you can use this for a fitness center.
Well, sure it is, and so that we know that it is.
Help me understand that, because it involves actions by third parties that your client would have to successfully get agreement with.
Well, remember though, when we're talking about the permits, right, there are other sections of the lease which speak to the parties' respective obligations.
Right.
Who is going to get a permit? This speaks to our ability to use the property. And it is augmented by Section 2.2, which was completely ignored by the underlying court. And in fact, the trial court read into 2.2 this idea that we could only interfere with the reps, warranties, and covenants of 2.2 if it was the conduct of the landlord. But that doesn't appear anywhere, right? That doesn't appear in 1.9.
How then, if that argument's true, how am I wrong on the permitting question that I asked?
If, in fact, we couldn't get a permit,
Yeah.
and it was our obligation within the lease,
Right.
well, then you would have an argument. But that's not what we're talking about here.
Well, and I understand what you're saying, although you're saying, if I hear you right, that 1.9 says, hey, we had to be able to use this as a fitness center throughout the entire time of the lease.
Well, it's not just 1.9. So remember that 1.9, 2.1, and 2.2 are to be read in conjunction, as with the balance of the lease. But
Yep.
obviously we read all of these to give meaning to all of them. So 2.1 says that...
Well, I have two questions before you
Sure.
move on, which is there anywhere in this lease where it says the landlord warrants that you will have the ability to operate?
Yes.
The landlord warrants you will have the ability to operate this as an exercise club, overriding your ability to get permits or anything.
Yes. You're
Where
right.
is the
So that's in
landlord warrants?
2.2, right? So 2.2 starts with in consideration for tenant entering into this lease. So we know why these reps, warranties, and covenants are being made. It says the material, and then it says my client's relying upon them, and that they will survive execution of the lease. So that's the preamble. So what did they say?
So where's the warrant?
Landlord shall have good and insurable title, title being ownership, to the
And
premises.
there's no allegation that that was breached?
No,
Okay.
They had ownership.
Right.
In fee simple. The problem was that that ownership in fee simple was to be free and clear of all conditions and restrictions. All, not some, not discrete ones, but all conditions and restrictions which might in any manner or to any extent prevent or adversely affect the use of the premises by tenant for tenant's initial uses or disturb tenant's peaceful and quiet possession and enjoyment thereof. Right then and there, landlord said, you will have the ability throughout the term, because we own the property without restriction or condition.
And that's still true.
Well, it wasn't.
That was also true during COVID.
It wasn't, respectfully, Your Honor, because beginning on March 20th, 2020, there were restrictions on the property.
But
Which,
let me tease this out, because that was
Sure.
my second question. Those restrictions, those COVID restrictions, were essentially a suspension of your permit. The government said, notwithstanding the fact that you have permits, your permits to run hairdresser salons and nail salons and exercise clubs, you can't do it right now. They basically, I mean, you can, but they didn't say we're suspending the permits, but that was the actual effect.
well, but what the actual effect was, Your Honor, was that those were conditions and restrictions that were imposed upon this lease that prevented us from using the property, from preventing us from getting peaceful and quiet possession and enjoyment of the lease.
But counsel, let me ask you on that.
Sure.
That provision, everything you're talking about modifies good and insurable title, right? And you've told me, I think, that you're not claiming that the landlord lacked good and insurable title.
No, what I'm saying is that they needed to own the property free and clear of any, not just some, any conditions or restrictions. Remember, we're trying to give intent.
Let me ask you, though.
Sure.
And then I have a couple of questions on the intent part. You're not claiming the COVID orders was a cloud on the title of the land.
No, I'm saying it was a restriction on our ability to use the property. Remember, what we're talking about here, right, are conditions and restrictions which may, or which might in any manner.
And I have the language in front of me.
Right,
You're just,
to any
you're just
extent.
carving out the have good and insurable title beginning of that sentence.
Well,
That's my struggle.
Sure. So what the landlord was saying is that, first of all, we'll own it, right? And then how will we own it? We'll own it in fee simple. What will the fee simple look like? Fee simple will look like there will be no conditions and no restrictions. This wasn't something where they limited the conditions and restrictions, which they could have. You know, they didn't limit it in terms of time. They didn't limit it in terms of type. If you look to the other paragraphs of 2.2, if you look to E, if you look to F, the parties, they knew how to limit by way of time or duration. In fact, they dealt with.
And counsel, let me interrupt you there. I'm
Sure.
sorry. You were beginning to mention intent, and I wanted us to engage on that.
Sure.
What, other than the text of the leases, what evidence of intent was provided to the Superior Court?
Well, but see, that's the problem here, Your Honor, is that in this particular case, with all due respect to the trial judge, he went and selected intents that weren't provided by either party, right, that were contradicted by the actual language. He said that, first of all, any interference with our ability to use the property had to come from landlord. He said that all of these representations, all of these covenants, were only good for the very first day. So when he said that the language in 22.1, the force majeure clauses, where they added additional language in 2 of the 3 leases, that had no effect. that had no bearing on the intent, but rather the parties did that because in his estimation, it was belt and suspenders.
And I understand, and have looked carefully at the court's ruling as well as the provisions in the lease, but just so we're on the same page, when you talk about intent, it needs to come from the four corners of the leases, correct? Nothing, there are no drafts offered, there's no declarations offered, there's nothing like
Well,
that.
see, we never got there, right?
Well,
So
it was motion for summary judgment and cross motion for
So
summary
it was a
judgment.
motion for summary judgment, cross motion,
Right.
and it was two motions that essentially provided, right, different meanings of the same clauses.
Understand.
Right? So right then and there, you have two susceptible meanings of the exact same language.
But
right? And
legal argument about their meaning, not evidentiary support that they mean something different.
Well,
That's my question.
Well,
to
but
you.
here's the problem. If in fact, and what the law in this state says, right, under Smith v. Melson and then the Taylor versus State Farm case, is that where there are two susceptible meanings of the same language, what the court is supposed to do is then entertain parole evidence to determine what the actual intent of the parties is, not to determine it on his own without any record evidence by either side.
And did your motion, cross motion for summary judgment, claim that the court shouldn't resolve it as a matter of law? I thought it did say.
So we believe, frankly, we believe that he got it wrong completely, that he should have ruled our way. But the alternative argument was, look, at a bare minimum, we should have been given an opportunity to go to trial. Right? We were foreclosed from all of this when the judge, without taking his interpretation, without taking my interpretation, imposed his own interpretation, which was not supported by any of the facts, wasn't an argument made by either of the parties. Said that all of this was something different, that he decided 20 years after the leases were written, this is what the parties intended, without any evidence from either side. And candidly, we got oral argument over the phone for about 10 minutes, and a decision came out later that day. So, with all due respect to the trial court, I don't think that we were given ample opportunity to present any of this.
The court had full briefing though, right?
So the court had full briefing.
Right.
So before I get too far afield, I did want to, so 2.2E, 2.2D, specifically, if you look to that, Your Honor, you'll see that the parties were well aware of how to limit both the types of restrictions, because 2.2D speaks to compliance with all applicable laws, building codes, regulations, et cetera. And then 2.2E speaks to specifically a duration of 12 months, right? So here, both of those are missing from 2.2B. And I think that's instructive in terms of trying to determine what the party's intent was. And essentially, the court wrote out all of that and then imposed its own version of what was the covenant of quiet use and enjoyment. What's interesting is use and enjoyment, in these leases appeared at least 3 times. But only once did it appear where there was limiting language that dealt with interference by the landlord or folks operating by, through, or under them. The law of Arizona says the parties don't say the same thing over and over again differently. They say things over and over again if they're meaning different things. And what the court did here was conflate all of those. Conflated those with a common law covenant of quiet use and enjoyment. And then obviously, I see my time is running up, so I'll leave it there unless you have some questions for me, because I want to reserve some time for
Very well. Thank you,
Okay.
Counsel. Mr. Turbinson.
Good morning, Your Honors, and may it please the Court. My name is Mitch Turbinson, and with me is my colleague Catherine Anderson Sanchez, and we represent plaintiff appellees Vereit Real Estate LP and Cole LA Glendale AZ LLC. For simplicity, I'll refer to them both as Vereit. This case is about the LA Fitness chain of gyms attempting to evade payment of rent obligations despite providing no evidence that it was unable to make those obligations, to satisfy those obligations. Notably, while Fitness is attempting to use the governor's executive orders to excuse rent, the record's clear that it has withheld rent for months like June 2020, in which the governor's orders were in place just 2 days out of 30, and is withholding the entire month. The court should affirm the trial court's grant of summary judgment in favor of Vereit because there's no basis under the respective leases or under Arizona common law that permits LA Fitness to shift risks inherent in operations to its landlords. As a preliminary matter, I wanted to be sure the court received 2 supplemental notices. One was filed Friday and one was filed Monday.
We have, counsel.
Okay. And I want to direct the court's attention to it. I know my colleague was counsel on the case before the California Court of Appeals, the SVAP 3 Poway Crossings LLC versus Fitness International case, which is certified for publication and rejects the exact same force majeure, frustration of purpose, impossibility and practicability, and breach arguments Fitness presents in this case. There's minimal difference in the lease language between the lease at issue in that case and the 3 leases at issue in this case.
That case was under California law, correct?
Correct.
Just a question in that case, does it include the one sentence that is different?
It does not. It does not include it's like the Morano lease.
It's the Morano lease.
Yep.
Okay, thank you.
And the second case, there's another opinion in the Colorado Court of Appeals. That involved different parties. That's the Highlands Broadway versus Bar Boss case, which was issued, the opinion was issued last week. That one is relevant for the analysis of frustration, purpose, and impossibility. So turning to the force majeure language of the Morano lease, notably, as Judge Goss asked, there's identical lease as the Morano lease in that it does not include the additional sentence that the Glendale and Avondale leases have. As the trial court did here, the California Court of Appeals held that the provision did not excuse rent because Fitness was not delayed or hindered in paying rent. And separately, the second sentence, the quote, delays or failure to perform resulting from lack of funds language, made it even more explicit that it excluded payments of rent from its applicability.
That case, though, dealt with one lease provision, right?
One lease provision.
One lease, I should say. And one of the confounders, it seems, in this case is we have 3, 2 of which have sort of one provision, and I think the Morano lease is the more recent of the 3. I'm not positive, but has a slightly shorter provision that deletes a sentence. And that, obviously caused some litigation in Superior Court and a difference of views up here, or here, I should say. So how, above and beyond being different law, and other things, how should that difference affect how we consider that case?
Well, I believe that both courts use the standard, the plain language of the contract governs. With regard to the 2 other leases at issue here, the court shouldn't consider those at all. The Fitness is not appealing the court's ruling on the force majeure as to the Avondale and Glendale leases. All 3 leases were entered into by separate landlords and later assigned to Vereit, which is a real estate investment trust. And so whether Fitness, used one language, whether one party to a transaction uses language in one place and then another with another party has no effect over a third party entering into an agreement with that party. I mean, under the parole evidence rule, first of all, there's no relevance because we believe the language is clear, so there's no reason to look beyond the 4 corners of the Morano lease. Under course of dealing, this isn't course of dealing evidence because it's different parties. There's really no value. It's not competent evidence. So the trial court's language about belt and suspenders is just not relevant on appeal because the belt and suspenders language was specific to the Glendale and Avondale leases, not to the Marana lease, which is the only issue on appeal.
Let me ask you a bit about procedural issues that I've spoken to Mr. Phelan about. We're here on motion for summary judgment, cross motion, right? Actually, a partial cross motion for summary judgment, I think. Was there any, what evidence did the court have in front of it in issuing its rulings, if any, other than the three leases and argument of counsel?
That's it. That's all that we believe the court needed, and that's all the court stated it needed with regard to understanding the plain language of the leases. This is a first on appeal that they're arguing that the lease language might be somehow vague and ambiguous. That wasn't the argument they presented to the trial court. Fitness didn't argue, we need more time, we need discovery, 56D motion. They didn't argue any of that. And so to come up to the appeal and say, give us a do-over before the trial court, that's soundly waived in my view.
Well, and you triggered another question. Discovery wasn't closed when these motions were briefed and when the decision issued, right?
Correct.
But as you point out, at least I don't recall from the record, a request saying, hey, we can't possibly brief this on either side, frankly, and we need more discovery, and here's what that discovery is.
Right. And in my view, we were trial counsel. I can't think of what discovery that would be between the parties that should have been provided to the Superior Court. And certainly Fitness hasn't argued there's some type of draft out there that would be helpful to the Superior Court or some type of anything. Testimony, they present testimony from Ms. Diane Alexander, who didn't argue that there was any ambiguities. And so I think the record is closed and enough for a court to make its decision. And as a third point, on the force majeure provision, another issue that the Superior Court recognized, that all the force majeure provision does is delay. It doesn't excuse anything. And so as I think the Superior Court said with regard to the frustration of purpose argument, the time has come and passed. What's your excuse for not paying, continuing to not pay? There is no excuse, at least that Fitness provided. Regarding Section 1.9, again, SVAP dealt with that language, and this is just, the language itself is just not operating as a guarantee. It's an acknowledgement that Vereit would not prohibit Fitness from using the premises for its permissible uses. Notably, Fitness has not cited one case, and as you've seen, a lot of Fitness's leases look alike. They have not cited one case that's globbed onto this language as a basis for finding in favor of Fitness. I don't believe the Texas trial court in Dallas, which is on appeal, did that. I don't believe the Miami case that they've cited did that. There's no other cases. Instead, you have a case that's going to be published that looked at the same language in California and said, not a guarantee. You have multiple, you have the Central District of California case, DDRM, and you have a few Superior Court cases in Los Angeles, Andrews Rancho del Sur, 5900 Wilshire, that all looked at the same language and said, this isn't a guarantee.
Counsel, let me ask you about those other cases, and then I have a follow-up on force majeure. To your knowledge, do any of those cases apply Arizona law?
No.
Okay.
And I don't think they need to just simply read a contract and determine its plain meaning.
And I understand your position on that, but each state at the common law, and that's where we are, the UCC has nothing to do with this contract. Each has its own dialect or perhaps sometimes different language, and that's why I asked the question. So those, and we have looked at those, and they're helpful that both parties have cited, but they're not binding on us. And are you aware of any Arizona opinion applying force majeure? Because I am not, and I've looked pretty hard.
No.
Okay. Which surprised me.
Right. I think most of it, I don't know if that would be very helpful. The reason that these cases are almost more helpful is because they're looking at the exact same language versus, some older case in Arizona that might be looking at different language.
And I understand that force majeure is a way to allocate risk as to typically a third party or a third something beyond the control of the parties. And so it is very much language dependent. But Arizona's kind of the empty set on how you construe that.
Yes. And but taking it back just to the SVAP case and its reasoning, it looked at the similar language we have here in Section 1.9. It looked at Section 8. It looked at the plain language, said this is not a guarantee, bolstered that opinion by looking at Section 8.2, which is also in these leases regarding the ability for fitness to change its use, and said this isn't a guarantee because you have the ability to just change your use. And one other thing, to the extent this could even be construed as a guarantee, the force majeure provision would apply here. As the trial court referenced, the force majeure provision, if it was our obligation as landlord to provide premises for a specific use, and the government restrictive laws came in place and said, we're not allowing that use, that is the force majeure provision for us. And so to any extent, the 1.9 would be displaced by the force majeure provision on our benefit, not on tenant's benefit.
Counsel, appellant has argued that the trial court came up with some theory or approach that none of the parties had mentioned or suggested. What do you have to say on that?
We briefed, the judges, certainly the judge didn't, copy and paste our briefing, and we didn't submit a proposed order. But he adopted our arguments, he addressed our arguments, and I don't believe that there's any section of the order that we didn't argue in our briefing, and certainly fitness hasn't pointed out which section that is. And one final note regarding 1.9, even if there was a guarantee, there's been no evidence that all uses permitted were displaced or prevented by the executive order. And I'll direct the court's attention to the language in Executive Order 2020-09 on fitness, appendix page 44, which was specific to gyms and fitness clubs. It didn't say, for example, pro shops or some of the other uses described in the section or child care facilities or vitamin supplement sales were also displaced. As to section 2.2b, the good insurable title, I don't know if that deems much attention from us. Judge Goss and Judge Thuma, you I think adequately expressed that the subject of that sentence is good insurable title. There was no cloud. The governor's order didn't suddenly put a cloud on the title. And so just simply preventing a use, I mean, that's an expansive argument that could create many new arguments if that one were to prevail. As to quiet enjoyment, I'm surprised a little bit that that's being raised now because in the reply brief on pages 4 and 5, Fitness International acknowledged that quiet enjoyment is really only disturbed by the landlord, not by a third party or someone associated with the landlord, which there's no evidence of that here. On frustration of purpose, again, even assuming that Arizona recognizes temporary frustration of purpose, which there's no case law that actually adopts restatement section 269. However, even if that's the case, it's a moot point because really all that 269 does, the specific language says that frustration of purpose that is only temporary suspends the obliger's duty to perform while the frustration exists, but does not discharge his duty or prevent it from arising unless his performance after the cessation of the frustration would be materially more burdensome than had there been no frustration. So even if the court were to adopt a temporary frustration of purpose, it doesn't discharge anything, and there's been no evidence that paying rent was impossible in the first place, but is now impossible years later. Also, as the SVAP court recognized with regard to fitness, when you have a 15-plus year lease, I think that lease was even a few years more, a temporary inability to use for whatever purpose you wanted to use the lease for a few months is not that's not substantial enough to trigger the frustration of purpose doctrine. And notably here, we're not even sure there was a frustration because certainly fitness didn't move out of all the buildings. They left equipment in there and all of that. And so I'm not even sure that they've really carried their burden there to show that they terminated the lease. They didn't terminate the leases. They continued to pay and are still paying at least under 2.
We would have to adopt the temporary frustration for that to prevail. And again, as you pointed out, then it's just a temporary suspension of the obligation.
Right. It doesn't carry the day for them. And this was actually what, the Bar Boss case kind of goes to is also foreseeability. In the Bar Boss case, there was a reference to restrictive laws in the lease. And notably, fitness's argument is that you need to, when a lease says restrictive laws, you need to know why the restrictive laws are in place. And the parties have to know the backstory. But force majeure clauses just talk about acts of God. You don't need to know, what caused the act of God. And to require that additional backing up to determine if something is foreseeable, one, isn't really recognized by any of the, at least, appeals courts that have dealt with it, including Colorado. But it also would kind of defeat the whole purpose of a force majeure provision. Finally, on to impossibility and impracticability. There's absolutely no evidence that was presented that fitness has been unable to pay rent. And in fact, we've attached discovery responses where they refuse to give us financial statements. They said it's not an issue. We're not arguing inability to pay rent. So the impossibility doctrine requires performance, not use, performance. They were not required to use, notably, they weren't required to use the premises except for one day, all 3. They were allowed to go dark. And so there was no obligation. The issue of why we're suing is not because they didn't continuously operate. It's they didn't pay rent. And I'd also direct the court's attention to the first supplement of authority, the National Retail Properties case against Fitness International, where the Michigan Court of Appeals held in favor of our arguments regarding the impossibility and said, basically, plaintiffs' focus on its inability to use the premises as a health club during the shutdown is misplaced. The focus is on did they have the ability to pay rent.
And counsel, in Arizona, the courts have combined those 2 defenses into impracticability.
Yes. Yeah. Same thing essentially. It's confusing in all jurisdictions what courts have done with it.
But we have one confusing doctrine instead of 2.
Yeah.
Okay.
Right. And finally, although it wasn't raised necessarily in the reply brief, the failure consideration argument, the right to possess the property is sufficient consideration. That's that. And I'm not sure that if that's still being argued at this point, given it wasn't raised in the reply. And actually that argument was waived because it wasn't even raised before the Superior Court, and we noted that in multiple places that, hey, they're not raising that. So in sum, unless there's any other questions, I'd urge the court to affirm the grant of summary judgment in favor of Vereit and Cole, and ask that the court award attorney's fees as permitted under each of the leases. Thank you.
Thank you, Mr. Turbinson. Mr. Phelan, rebuttal.
Thank you, Your Honor. Just briefly. I'll try to address some of the points raised by counsel. Counsel said we didn't provide financial statements. We didn't argue that we didn't have the ability. What they're essentially trying to create is 2 different standards. If you have money, then you can't avail yourself of any of these legal propositions. And if you don't, then the law provides you additional protections. That's not how the law works, and that's been a continual theme here. We've never argued that we didn't have money. We argued we didn't get the benefit of our bargain. We leased these spaces for the express purpose of using these spaces. Nothing more, nothing less, and we didn't get that. Right? So this whole idea about money, not true. With respect to counsel saying that none of the courts around the country have interpreted 1.9 as a guarantee, that's not true. I tried the case before a judge bench trial in Maryland. He found in our favor. We argued it in New York. Not only did we win in New York, but it was affirmed on appeal by the New York Court of Appeals, 4th District. So that's not true either. What we're here today is to talk about these leases. When the judge spoke about force majeure, and I just want to get into force majeure and temporary frustration.
Briefly, counsel, time goes fast.
Sure, I get it. When you look at the force majeure language and you look at the judge's decision, what he says is that we weren't prevented from paying rent. That's not what the actual provision says. It says hindered, delayed, or prevented. There was no evidence for him to conclude and to write out of his opinion hindered or delayed. Right? There's none of that. Right? We should have been given an opportunity. With regard to temporary frustration of purpose, right? The law is clear. We're not looking to apply 265 or 261 of the Restatement Second of Contracts. That would be relief we were seeking if we were trying to get out of this contract. We're not. The moment we could reopen, we started to repay. The reason we didn't pay was because we were temporarily frustrated in terms of using it.
Thank you, counsel.
Thank you.
Counsel, we appreciate your written filings, your briefs. We appreciate your oral argument today. You've given us much to think about. We will take the matter under advisement, and we'll issue a written ruling in due course.
Thank you, Your Honor.
Court stands adjourned.
It's always